of Judge McBrayer and Judge Golden, we want to thank counsel for participating in this oral argument via Zoom, and by which we are live streaming your argument. Also, please note that the argument will be posted on the AOC website for future reference by you and the public. We will conduct the argument in the same manner as if we were all in the courtroom together. And of course, each side has 15 minutes for your argument, with the appellant having the benefit of reserving some for rebuttal, which I understand you've already done. So unless there are some announcements, I'll ask Mr. Hivner to call the case.
Department of Finance and Administration, Division of Tenncare versus the Chattanooga-Hamilton County Hospital Authority, doing business as Erlanger Health System.
You have the floor.
May it please the court. Good morning. My name is Meredith Bowen on behalf of the Division of Tenncare. I have reserved 2 minutes for rebuttal.
Certainly.
This appeal stems from an administrative proceeding following the remand from the Tennessee Supreme Court ordering Erlanger to exhaust its administrative proceedings. The appellee in this case sought a declaratory judgment against Tenncare regarding the rate of reimbursement for out-of-network emergency services provided. The issue presented herein is whether the ALJ in the administrative proceeding erred in excluding 4 exhibits proffered by Tenncare, objected to by Erlanger. The standard of review as to whether or not the exhibits constitute hearsay or fall under any hearsay exception is de novo. And the standard of review as to the determination of whether the exhibits fall under the relaxed UAPA standard is an abuse of discretion standard. I will note, though, that decisions shall be set aside when a court has, as we argue, misconstrued controlling legal principles. To begin, the ALJ erred in excluding exhibits 1, 3, and 5, where they do not constitute hearsay. These exhibits do not constitute hearsay where they were not offered by Tenncare to prove the truth of the matter asserted. They were provided in the administrative proceeding to show the effect upon the listener. These are 3 sets of email chains where Tenncare was in communication with the Center for Medicaid and Medicare Services, CMS, and the Tennessee Health Association. And although the statements included in them are not offered to prove their truth, these email chains were offered to show the effect that these communications had on Tenncare in creating, writing, and promulgating the rules at issue in this case. We cited in our brief to State v. Hawkins, but we also pointed out that in Lawrence v. Erlanger, Erlanger itself has previously argued this very issue based on the vitality of a decision-making process and the ways in which there is an effect that communications have in a decision-making process and are therefore admissible when not to show the literal truth. Even if this court were to find that these exhibits constitute hearsay, all 4 exhibits fall under the business records exception, Rule 803(6). As we described in our brief, these exhibits meet all 5 criteria for the business records exception, and the statements contained in the email chains that are Tenncare's are certainly admissible under the business records exception. The statements contained in those email chains that are CMS's or THA's would be provided and admitted to show context. And this is consistent not only with other administrative proceedings, but within this administrative proceeding itself, as we laid out in our brief, at least 57 other exhibits were admitted, and there was consistency in that there were business records and other aspects of email chains admitted to show context. Again, it's important to note that Tenncare in this case, in terms of these 4 exhibits, is specifically seeking consistency. And that the issue taken with the ALJ's determination as to these 4 exhibits is that there's a lack of consistency at the administrative level in terms of what was and wasn't admitted. As Erlanger points out in its brief, well, why didn't Tenncare object to the exhibits that are comparable on their side? And the answer is simple. Why would we have objected to exhibits that are consistent and comparable to the ones we wanted admitted, that would be inconsistent. We would be asking for inconsistent rulings from the ALJ. The idea that email chains like this are standard business records in a case like this, certainly at an administrative level where we're creating a factual basis, a record on this behalf, to allow the agency to review its own rules, its own rulemaking process, its own rulemaking determination. The idea that we would somehow prevent them from reviewing the record in its entirety as to its own business records lies in the face of case law.
You talk in the reply brief, the state does, about the distinction between the standards of review here between the hearsay determination and then the just generally admissibility of evidence. And one of the things you mentioned is the fact that the ALJ did make a determination about relevancy here. Are you suggesting we shouldn't consider relevancy in this case?
I think that the relevancy issue has been inherently present since the moment of proffering the exhibits. The idea that
certainly the chancellor seemed puzzled about what probative value these emails would have, and I'm struggling with that as well. You say in the lead brief that they're needed because Erlanger has consistently alleged throughout this litigation that Tenncare acted in bad faith in adopting these rules. I mean, what does that bad faith determination get you? I mean, what does that issue revolve around in the underlying administrative proceeding? I mean, what role does bad faith play?
Absolutely. First and foremost, that's a question for Erlanger. We are not the ones who proffered that argument in the first place. In their amended petition at the administrative level, page 6, the second full paragraph, they discuss the ways in which Tenncare intentionally omitted or ignored the DRA, the ways in which they failed to disclose certain items. And we have simply consistently been responding to those allegations of intention, bad motive, bad faith somehow in promulgating these specific rules that now they're calling into question. This issue of intent and motive and relevancy has been present since the inception of the previous case for which this issue was remanded to exhaust the administrative proceedings. The Tennessee Supreme Court itself, if you look at their opinion at the Erlanger case, discussed the ways in which Erlanger needed to exhaust the administrative proceedings because its allegations were in some way that Tenncare had, again, failed to properly promulgate these rules. And so we needed to go back in time, go to the administrative level, and allow the ALJ to review how and why these rules were created in determining whether or not they are in some way a violation. And so the idea that they're relevant, that CMS's participation in how and why these rules and regulations were created by Tenncare, it goes to the heart of the case and the allegations raised at the inception by Erlanger itself. It hasn't purely been sort of an abstract idea that these rules just are invalid. The allegations have consistently from Erlanger at every stage of litigation, both during this case and the prior civil suit, consistently alleged bad faith, bad motive, intentionally failing to disclose, intentionally failing to ignore certain aspects, and any response from Tenncare to that argument has been consistent from day one. And these
hypothetically, if Erlanger were to stipulate today that Tenncare wasn't acting in bad faith, maybe just inadvertence or oversight, then these emails wouldn't be necessary.
I would disagree. They would still remain necessary because they go to show the how and the why, even if you're not alleging bad faith or ill motive. The idea that Tenncare wants to show at the administrative level how it came up with its own rules and regulations is standard at the administrative level when reviewing these kinds of things. And these email chains go to show, as with all rules and regulations out of Tenncare that have to do with Medicare and Medicaid, there's a stream of communication back and forth with CMS THA, for which Erlanger is a member, there's a back and forth and a communication. And the idea that you would exclude those kinds of communications that show the effect of their opinion on Tenncare's thought process, their directives, which Tenncare would then feel bound to follow in order to have the waivers approved at the federal level and to have the rules and regulations remain valid. That's standard practice with Tenncare in terms of the promulgation of rules like these. And so even if you were to exclude any allegation of intentional bad faith or ill motive, they're still relevant because they go to show how these rules that are now being questioned were created.
Does it make any difference if they don't comply? If they don't comply with the statute, does it, I mean, are they relevant if if they don't comply? How you arrive there, does that make any difference?
If the rules themselves don't comply?
Right.
I think when reviewing whether or not they do comply, how and why they were created, the guidance that formulated them is what could be more relevant. And I think, Your Honor, in terms of, again, relevancy, which is sort of part and parcel of why these exhibits were proffered, this all goes to show our third argument, which has been from the ALJ level to now, really the heart of our position. This is why the relaxed standard under the UAPA 4-5-13 was created. So that if you have questions of hearsay or questions of relevance or questions of admissibility, at the administrative level, there is a relaxed standard for this very reason. And in this case, the ALJ abused his discretion where he misconstrued this standard. In his opinion, excluding them, he referred to them as being incapable of proof. And although we couldn't perhaps surmise that he was attempting to find a synonym in incapable for what the actual standard is, which is not reasonably susceptible, meaning not reasonably accessible or admissible, he misconstrued the standard and narrowed it to a way that then he excluded these exhibits, whereas they fall under the standard to a T. The idea that they are commonly relied upon by a reasonable person, email chains, reasonable course of business. This is over 10 years ago. These are all employees who are no longer employed by any of their specific agencies. The idea that you can't subpoena to depose CMS employees. The idea that you would then, even though it falls under this standard, misconstrue it and exclude them flies in the face of case law. I'm sorry, Your Honor, I thought you were going to ask a question.
No, well, I was, but that's fine. Go ahead.
Okay. And I think based on this relaxed standard, these 4 exhibits are admissible. They are not reasonably susceptible to proof under the rules. They are the type commonly relied upon by a reasonable person. The ALJ misconstrued and therefore abused his discretion, and this court has leave to reverse his decision and to admit these 4 exhibits. If there's no further questions at this time, I'm.
Thank you, General. You'll have time for rebuttal. Mr. Reynolds.
Good morning. May it please the court. I'm Greg Reynolds here for the appellee, the Chattanooga-Hamilton County Hospital Authority, doing business as Erlanger, a nonprofit, publicly owned hospital system in East Tennessee. I want to begin by picking up on 2 questions, the question from Judge McBrayer and the question from Judge Golden. First, our petition does not raise bad faith. Heretofore, in their briefing, the Tenncare has referred to a different proceeding, a different lawsuit that is related, but nevertheless is not in the record here. We don't allege bad faith for purposes of this lawsuit. This is a challenge to administrative rules. And as Judge Golden asked, what difference does it make what good faith or bad faith or no faith Tenncare utilized if the final product does not comply with the law. And that is what we're here about. That's what this proceeding is about. This is a very narrow proceeding about whether the Tenncare rules that were put in place complied with the letter of the Tennessee statute. They don't, but that is something that will be shown as this proceeding goes on. This appeal, however, is a narrow appeal over the admissibility of 4 exhibits, all of which are emails that contain multiple levels of hearsay and are inherently unreliable, as the Chancery Court observed. Exhibit 1, for instance, is between Tenncare employees and an employee of non-party CMS passing along from other CMS employees informal advice about the Federal Deficit Reduction Act. So it's multi-level hearsay by a non-party. 2 points regarding this exhibit are particularly relevant. First, ultimately, the exhibit doesn't even answer Tenncare's question. So if the court reads this exhibit, there's no answer ultimately to Tenncare's question that Tenncare contends it relied upon. Second, and even more disturbing, this exhibit cautions against reliance. The CMS employee's email says, quote, "Any opinion expressed in this email communication does not represent the opinion of the agency and will not bind or obligate CMS," close quote. The exhibits 3 and 5 serve merely to pass along an attachment, and that attachment doesn't have an author. Tenncare, as it sits here today, doesn't know who wrote that exhibit. That exhibit purports to recount the happenings in a telephone conversation that Tenncare didn't participate in. So it's multi-level hearsay by an unknown author describing a communication that Tenncare never participated in and has no knowledge of. It's not a business record. Exhibit 4, one clarification in what Ms. Bowen said in her oral argument, Tenncare does offer Exhibit 4 for the truth of the matter. They're offering it for a hearsay purpose. Exhibit 4 is an email between a non-party lobbying outfit called Tennessee Hospital Association and Tenncare, attaching a draft memo that was prepared by a clerical worker at THA and purports to describe happenings at a legislative session that it appears this person never even attended. So we've got multi-level hearsay. We've got no corroboration. We've got no identity of authors. We've got blatantly unreliable hearsay. As Chancellor Martin aptly put it, rather than inherently reliable, the information in these exhibits seems unreliable. To circumvent this obvious hearsay problem, Tenncare makes 3 arguments. First, it argues that these exhibits are not actually being offered for the truth of the matter, except for Exhibit 4, but rather for the effect on the listener. The effect on the listener is purported to establish that Tenncare acted reasonably in light of the advice from CMS. But as Judge McBrayer pointed out, I think, Tenncare's mens rea is not at issue in this case. It simply is not. What is at issue is whether the rules that Tenncare put in place comply with the letter of the statutory Tennessee statutory law, not federal law, Tennessee statutory law. Does it comply with that statute? That's the narrow issue in this case. It obviously doesn't go to that. In fact, Chancellor Martin discredited Tenncare's assertion that it was offering these exhibits for a non-hearsay purpose. She wrote, "It appears that Tenncare is attempting to sway the commissioner's designee that the Tenncare rules properly incorporate the federal directive because Tenncare sought and acted in accordance with CMS and THA guidance." In other words, a hearsay use. It was not an abuse of discretion for the ALJ and for Chancellor Martin to exclude the exhibits. And by the way, on the subject of the standard of review, I'd like to point out that the standard of review by Tennessee Supreme Court law for the exclusion of evidence is abuse of discretion. There is a de novo review over the legal question of whether something fits within the hearsay rule and or an exception to the hearsay rule. If it fits within the hearsay rule, it cannot be introduced. If it doesn't fit, then it's evaluated like any other piece of evidence. And as the court well knows, trial judges don't often and don't have to express all reasoning for the exclusion of evidence. Common is a one-word affirmed, or, sustained, or denied. And that holds up on appeal because the court applies the abuse of discretion. And if affirmance is proper for any reason in the record, then it's affirmed. The second ground for admitting these exhibits offered today is the business records exception, but Tenncare itself admits that the affidavit it offered to support the admission of these exhibits does not cover non-party hearsay. So it doesn't cover the multiple levels of hearsay. It simply doesn't comply with 8036. Tenncare now argues that it should have been admitted in partial form, redacted form, but it didn't make that argument below, and so it's waived it. Furthermore, this context argument is a facade, because the context, if the court looks at these exhibits without the hearsay statements of non-parties, these exhibits have no use whatsoever. On their face, they mean nothing without those statements. So context is not a real argument. They don't put context to the Tenncare statements that otherwise have any probative value. They establish the only probative value that these would have, and that is hearsay. Finally, as Chancellor Martin pointed out, the purpose of the 8036 business records exception is to permit the use of inherently trustworthy business records. Here, as we've seen, Tenncare's exhibits are inherently unreliable. So it was not an abuse of discretion to exclude the exhibits. Finally, Tenncare argues that 4-5-313-1 justifies admission. It's noteworthy that this exception found in 313-1 is subject to the abuse of discretion standard. And Tenncare has the burden of proving two things in order for it to qualify. First, it had to show the evidence was not reasonably susceptible to proof under the rules of court. It made no effort to obtain this evidence in accordance with the rules of court. And so it made no showing whatsoever of any efforts to obtain it. And the ALJ was right to exercise his discretion to exclude that evidence. They have just now raised in their reply brief, I believe, or no, in their brief on this appeal, they have raised an argument of sovereign immunity, claiming that that somehow establishes as a matter of law that these exhibits were not reasonably obtainable under the rules of court. But again, they never tried. And two, it ignores the ability to proceed under the agency's rules or under the Federal Uniform Administrative Procedure Act to get these. So they failed entirely to prove that they had no way to get these exhibits into evidence. And so for that reason, the judge should be sustained. Second, they also failed to make a showing that these are reliable exhibits. As we've covered, these exhibits are inherently unreliable. They don't know who wrote them in some cases. These are multiple levels of hearsay, and they don't even include an ultimate answer to the question. Moreover, the emails are riddled with cautionary statements that make any reliance patently unreasonable. So as the chancellor wrote, rather than being inherently reliable, this information seems unreliable. And that disqualifies them from this exception under 313(1). Finally, admitting these exhibits would unduly prejudice Erlanger. Erlanger has had no opportunity to take the depositions of any of these non-party declarants. And that's particularly problematic here because the parties have waived the final hearing in this case. So this is a hearing on the papers and on the admitted exhibits. The parties conducted their depositions, and then these exhibits show up. We've got no ability to take the depositions. We're prejudiced here. These unreliable hearsay exhibits should be and were properly excluded. If the court has no questions, that's
I have one question related to your brief. You mentioned, Erlanger had mentioned possible waiver. This is admissibility under the statute. And I thought it was a sort of excessively broad reading of waivers to suggest that the state couldn't argue unavailability as a grounds for getting it under the statute. So it doesn't sound like you're pursuing that waiver type argument.
No, not that.
Because the issue is clearly before us about the admissibility of these emails, right?
It is
Yeah.
Indeed. I'm out of time. Thank you.
Thank you,
Your Honor.
Thank you, Mr. Reynolds. General, you have time for rebuttal.
Thank you, Your Honor. I'd like to make 2 quick points. The first is, again, only because I did not directly cite to it in my brief, page 6 of the amended petition in this administrative proceeding, the amended petition for declaratory judgment written by counsel for Erlanger, page 6, second full paragraph. Tenncare's failure even to cite the state DRA during the rulemaking process prevented the public from discovering that Tenncare had intentionally ignored the explicit requirements of the state DRA. If we could put to bed any issue of relevance as to how these rules were created, we certainly did not come up with it out of thin air. We are merely responding to the allegations of
But as
petitioner in the
but as
underlying
Judge
case.
Golden mentioned, why is that relevant when the issue is, does this rule and regulation comply with the statute?
It is relevant because the hows and whys of its creation are fundamentally going to go to show whether or not it is valid or invalid under the rules. And if I may, before my time is up, I want to respond to the allegations that hearsay disqualifies these exhibits, unreliability disqualifies these exhibits, in some way now argued prejudice in some way disqualifies the exhibits. That's inherently why we have the UAPA standard, for which the case law goes to show that hearsay does not disqualify it. In fact, hearsay evidence is admissible under this standard in these administrative proceedings. Unreliability and prejudice are not prongs of that standard. And under that standard, all of these exhibits are admissible. Thank you so much.
All right, thank you, General, and Mr. Reynolds, for your arguments. We will take this matter under advisement. Mr. Hibner.
Thank you.
This honorable court is now in recess until 1 p.m.